In this video, I'm going to be talking about what happens after a preliminary hearing in a criminal case. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be explaining what you can expect after a preliminary hearing in a criminal case. Now, this video is actually part 4 in a series of videos explaining a whole criminal case timeline, and you can actually find down below a link to download this PDF. And this is not marketing material. This is something I actually made for my clients, and that's what I'm giving you. It is the real deal. It is actually, what to expect, what happens. Okay, so after the preliminary hearing, it's generally 10 court days later, there is going to be another court date set called the information arraignment. Well, what the heck is that? And what happens in those 10 days? What is the difference between that first court you were in and the second court that you're probably going to get moved to? What can you expect? Okay, so first of all, within that 10-day period of time, usually not a whole lot happens. But in some cases, let's say that we weren't able to get a deal before the preliminary hearing because the DA said, well, let's see how my witnesses testify and then we can talk. Or maybe that as a defense that their witnesses are probably going to suck. There are probably going to be some problems, some holes that are exposed at the preliminary hearing. So you may be able to get a better offer within that 10-day period. So sometimes we will set up a meeting with the DA to talk to them more about resolving the case. And that is actually not in this timeline, but this is something that I think is important to know, this sort of transition period that happens, even though usually there's nothing. Sometimes that does happen within those 10 days. Okay, so at the court date, what can you expect? Well, the information arraignment is where you are told what the charges are against you. And you may be thinking, well, what the heck, Veronica, why? I already know the charges against me. Yeah, you do. It is just a matter of procedure. This is one of the procedures that's required for you to know the charges against you after the preliminary hearing. Now, some of you who have been through the system before or who have relatives that have been through the system may know that this second court that you're in, and usually it's actually going to be a different courtroom, different judge, sometimes different DA, depending on the case in the courthouse, than the first court that you were in for everything else. This new court is called the Superior Court. So you are basically in the trial stage, the trial phase, trial stage of the case after the preliminary hearing. So at this information arraignment, it's going to be very similar procedurally in what you hear in court to the very first court date. Waive further reading of the complaint, or in this case, information and statement of rights, enter a plea of not guilty. Right? So it is not a whole lot is going to happen actually during the hearing, generally. Your lawyer will get a copy of the charges against you, but of course we already know what they are. There are no surprises there. Your lawyer will also get a copy of the preliminary hearing transcript, so a transcript of what all the witnesses said at the prior hearing. And your lawyer, if we weren't able to within that 10-day period for whatever reason, usually the DA's schedule, talk to them about resolving the case, now we can use this court date to talk to them again and explain, okay, hey, whether it's the same DA or a different DA, here's what the witnesses said to the cops, for example, here's what they said at the preliminary hearing, or your witnesses wouldn't even show up, and this is another chance to try to get a good deal. Now, this date in general is not particularly important procedurally, but what is really important is that for the most part, most criminal defense attorneys or most courts will require any criminal defense attorney who represents someone at this information arraignment to actually represent them for the rest of the trial phase. So importantly, any attorney who sticks with you after this court date is going to probably charge you a trial fee. So some people will kind of wait till after the preliminary hearing to hire a private attorney. That is not a good idea. The best idea is to, if you have limited resources, use them to try to get the best possible offer early on. In the meantime, perhaps you can acquire more resources take out loans, whatever you need to, if you think the case is really going to go to trial. But trial fees are much, much, much more expensive than fees for the first part of the case before you get to the trial phase. So that's pretty much what to expect for the information arraignment. The next video is going to explain the court dates that happen right after that, which are pretty important. If you have any questions, feel free to write a comment down below. If you do have a case in California that you need help with, feel free to book a call with me. You can also find my number down below, and you can download for free this whole criminal case timeline that should give you a better idea of what to expect from your case.